No, I did not.
Oh, oh, okay.
I just, yeah, no, just enough to stay underneath the mask.
Is Tricia here? Yes. Perfect.
This was the mask I was going to wear. This is my favorite.
Oh,
I thought that might be inappropriate.
I don't know how.
I'm gonna wear my Slytherin mask today.
Maybe you should give it to somebody else.
I was gonna say, Dawn is here and she has my Eagles now. I do. Show off your handiwork. Thank you. I'm sure it will. Oh my gosh, look at that. Fancy, huh? Fancy. Okay.
You got your Eagles.
Dawn fixed it for me.
Oh, what was wrong with it?
It was one of those masks that had like the wrap around the head, had the two bands, and I didn't like that. I like the one with the ears better.
Yeah.
So she is a woman of many talents, one of which is a seamstress.
She takes after Sarah White, who makes cushions, wedding dresses, baseball uniforms. And she made baseball uniforms for, who's the singer with Kenny G? Michael Bolton.
Oh,
Or is
this
the,
with Kenny G?
no, Michael Bolton. He's baseball.
Oh,
Yeah, they got the contract when she was on. And she makes wedding dresses, did. And she makes canvases for the boat. She's got 3 different sewing machines. The best one she's got, which will go through leather, is a 1920 Singer.
Throw an object at the
wow. It is 156?
Years and years of sun.
It's a great one. It's much better than the newer one. It's got an overlocker, which I don't even think you probably know what that is.
I have no idea.
Either do I. But apparently it's special stitching. But yeah, she's pretty talented
Top
with
my right ear,
sewing
part
machine.
of it taking.
And all their kids know how to sew too, boys and girls.
That's great. When I was in Quebec, they tried to do
Yeah, they lived on a farm and they made them.
I can sew a button back on and I want to fix it.
Good afternoon, everyone, and welcome to the Delaware Public Service Commission meeting of October 27th. It's my pleasure to begin the meeting with a special announcement, and I'm going to come around here because the cable people have put a, I think that'd be useful in wartime, that type of a cable. It's going to trick the enemy up. Patricia Cannon, where are you? Everyone, and welcome. Commissioners and the Public Service Commission would like to congratulate Tricia on 10 years of state service. In August of 2011, with Delmarva Power and Light. And she's been instrumental in a lot of activities, and a lot of rate cases over the 10 years, and she's helped us, Matt calls her sort of the PSC Swiss Army knife, because she got a wide variety of talents that we used on behalf of the commission. Where's the camera? They shoot it right here, right? So I'll have the camera. Thank you so much.
Whose is this?
It's a delay.
Mike Correa, Commissioner Correa, are you on the phone? Commissioner Correa, are you on the phone? He was on the phone. Obviously, we have 4 commissioners present, as you can see physically, so we have a quorum. We have the reading of the meeting minutes of October 6th. So are there any changes or corrections to those meeting minutes? Commissioner Gray.
Mr. Chair, I move that we adopt the meeting minutes as submitted. I second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Commissioner Correa, I think you can vote.
Mr. Chairman, I'm not voting because I was not in that meeting.
Okay, well, that's a very good reason. Thank you very much, Mike. The consent agenda. Are there any items on the consent agenda that any commissioner wishes to move to the regular agenda? Commissioner Conaway,
Move that we adopt the consent agenda as presented.
I second.
is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any opposed? And no abstentions because Commissioner Correa. Okay, we have the regular agenda. The first matter is in the matter of the application of Artesian Wastewater Management, Inc. for a certificate of public convenience and necessity to provide wastewater service, and we have proposed order number 9862, and I believe we have Courtney Emerson from Artesian Water Company to help out with this matter. Welcome.
Thank you. Good afternoon, Chairman and Commissioners. We have before you Sand Hill 1900 docket number 21-0536. As a matter of efficiency, I would request that because they share the same legal and factual basis, that we would consider that along with Sand Hill 1200 docket number 21-0587. Is that acceptable to the Commission?
Which number is that again?
It would be regular agenda numbers 1 and 2. It's docket 21-0536 and 21-0587.
Yes, that would be highly appropriate.
Thank you. Commissioners, we understand that there was an opposition filed by the town of Milton. I don't see the town of Milton's counsel here. I was proposing to have these heard after the 2:15, which would be reordering your agenda as a matter of efficiency, because Mr. Mandalis had previously represented that his opposition to the CPCN applications could be resolved if the 2:15 application was approved. However, not seeing Mr. Mandalis, if you would prefer, we can proceed with these.
Let's proceed.
And can I just confirm he's not on the phone? Should I just proceed as if it were uncontested?
Is there anyone on the phone who wishes to be heard in this matter? Silence.
Okay, thank you.
Mr. Chairman, I'm sorry,
Yeah,
Ms.
Mr. Walsh.
Emerson, to interrupt. Mr. Mandalis sent me an email this morning, and I think he was not sure whether he was supposed to appear in person or he could do the live stream. And I advised him that Commission's expectations per the agenda were to appear in person, that the link was a view, not participate link. And as an alternative, he could call in and seek permission to appear telephonically without telling him whether that would be granted or not my place. He has an opposition in both of these, the regular agenda 1 and 2, as well as the 2:15. So I just put that out there and for the record.
Why don't we pass over these first two? Ms. Emerson, could you call him and ascertain if he's going to be calling in, which would probably be most efficient?
Certainly, I will try. Thank you.
And so we'll go on to number 3. In the matter of the application of Delmarva Power and Light Company for an increase in electric base rates and other miscellaneous tariff changes. And we've got Dawn Kurtz-Crompton for DP&L. Welcome.
Good afternoon, Commissioners. Thank you, Chair Winslow. Dawn Kurtz-Crompton on behalf of Delmarva Power and Light Company. This afternoon, we are here to address Delmarva's withdrawal of its motion that was filed on September 21st. This is the motion to modify the excess deferred income taxes balances, which we filed in dockets both 170977 and 200149. As this commission is aware, we did file this motion back on September 21st. And subsequent to that, staff, DPA, and DUG filed responses to our motion. We engaged in discussions with the parties with respect to resolution of the motion. But as stated in Delmarva's letter, we heard some additional concerns from staff and DPA with respect to our motion and with respect to this issue in general. And after further reflection, Delmarva has decided to withdraw its motion. This was a contentious matter, as I'm sure this commission is aware. And in furtherance of future resolution and collaboration, Delmarva has elected to withdraw its motion for the reasons stated in our letter. Since the revenue requirement was already adjusted to remove the EDIT balance from our request, it is Delmarva's position that no further orders need to be entered at this time in order to reflect the withdrawal of our motion. I have been advised by staff, DPA, and DUG that they do not, that they support our withdrawal, that they do not oppose our withdrawal. And the parties have also discussed that we would memorialize this issue more fully in the forthcoming final written order that we expect to be submitted to the commission in the coming weeks or months. So we just would like to thank the parties for their work and engagement on this issue and would respectfully request to withdraw our motion.
Thank you. I'm assuming, since no one else is speaking up, that there is no objection to the motion to withdraw. Commissioner Drexler.
Yes, I would like to make a motion to accept the withdrawal of motion of Delmarva.
Second the motion?
Is there any discussion on the withdrawal of the motion per DPL's request? Hearing none, all those in favor signify by saying aye.
Aye. Aye.
Aye. Aye.
I'm not sure about Commissioner Conaway's vote. Were you?
said aye.
Oh, you were involved in this case?
Oh, I never thought.
I think she has to abstain since she didn't hear the case.
Point of question, was Commissioner Correa a part of this case as well?
I think he heard the case. He was here, I believe. And he has voted. Mr. O'Brien.
Chairman Winslow, Commission Counsel, I believe the earlier orders had one commissioner abstaining and one commissioner absent. Commissioner Conaway was abstaining and Commissioner Correa was absent for an earlier one. So it would be appropriate for the order just to have the other three signatures and votes on it.
Withdraw my second.
Okay,
Who made the motion? All right, can we modify this in such a way that I second Commissioner Drexler's motion, since I was here for all of the case?
she's saying yes.
I withdrew my second.
All right, so I
She's very
second,
shy.
I second Commissioner Drexler's motion.
So that is amended to reflect those changes. Okay, thank you all very much.
Thank you, Your Honors.
We need a
Commissioner-
vote, sir?
You might as well just vote on that
Yeah,
last
we need to
one.
vote.
Vote on, yeah.
Yeah.
Okay. How does everyone vote with respect to what we just discussed?
Aye.
Aye.
Okay, 3 ayes, it passes. 3
Abstain.
ayes. Okay. Number 4, in the matter of the application of Delmarva Power and Light for an increase in electric base rates and other miscellaneous tariff changes. Mr. Jordan.
Good afternoon, Mr. Chair, Commissioners. Brian Jordan on behalf of Delmarva Power and Lights. I can proceed, but I think Mr. O'Brien actually prepared the order.
Gosh, Mr. Walsh wants to talk and Mr. O'Brien wants to talk. And I can't tell because that mask on is the... Mr. O'Brien, we'll
Sure.
go with you first.
Thank you, Chair Winslow. As Commission Counsel, I was directed after the last meeting on this subject to prepare an order memorializing the vote of the commission regarding its earlier reprimand order. I did that, and I circulated amongst the parties. So if there had been no objections to my proposed order, you could just vote on it now. But since each party, including staff, had certain changes that did not make it into this final draft, there may or may not be objections today. So normally I would be the only one presenting and say, here's the proposed order. But since we did not get buy-in, it would be appropriate for you to ask the parties if they have any objections.
Ms. Iori?
The public advocate takes no position on the proposed order.
Mr. Jordan?
Thank you, Your Honor. For Delmarva Power and Light Company, we support the proposed order number 9893 that's Commission Counsel Mr. O'Brien prepared. We support it as presented because it accurately addresses the deviation from the settlement agreement. It accurately reflects the issue that was briefed and presented to the Commission. It accurately reflects the deliberations and Commissioner comments from the October 6th hearing. And it correctly recognizes that the regulations already contain a penalty provision for the MFR or any MFR violations. And with that, Your Honor, we do support the order that's in front of the Commission.
Thank you, Mr. Jordan. Any questions, commissioners? Mr. Walsh, you want to speak, please?
Thank you, Chairman Winslow. Tom Walsh on behalf of staff. Our concern here, when this order was circulated by Mr. O'Brien, was the fact that it was isolated to minimum filing requirement.
I'm sorry, Tom?
It was isolated to minimum filing requirement 2.1.5. And in reviewing the transcript, there are many references to the minimum filing requirements. And the question, therefore, is on October 6th, in the Commission's deliberations, whether this was, whether you intended to issue a warning just as to future violations of this one particular minimum filing requirement. And when I read the excerpts, I made some notes, and MFR appears just twice versus MFRs, plural, 18 times. And I would just like to put into the record a couple of those. Mr. Jordan, and this is all from the transcript of October 6th, on page 2230, lines 10, 13, through 2231, 1 through 13. And it's, quote, however, as I mentioned, the concerns that staff raises have been taken to heart. There's been a process put in place so that, again, to try to reduce the risks that this happens again. Part of that includes taking closer looks from the legal department, myself included, at previous settlement agreements. Delmarva also looked at, when it takes this sort of action, is this first coming to the other parties. Of course, getting their position on this to avoid this from happening again. And then, when it comes to filing a rate case in the future, the company has come upon a checklist against the minimum filings. When Commissioner Gray asked at page 2254, lines 13 through 16, wasn't there an order with respect to the EDIT refunds under which the company should have been operating? Mr. Jordan replies, yes, that's where the mistake came down to, Your Honor, that settlement agreement. And let me go back to Order 9863, rather, because that's what's in there. It's about a deviation from the settlement agreement, not these minimum filing requirements. And that's where the problem comes, is the company went away from or deviated from the settlement. Chairman Winslow, on page 2258, starting line 23, and continuing on to page 2259. So this whole situation is troublesome because the minimum filing requirements have a purpose, and it's stated right in them. And of course, the company failed to abide by the minimum filing requirements. Of course, it's problematic, because when you look at the minimum filing requirements and what everyone is supposed to do, it doesn't anticipate this situation. And so we're left, as everyone has pointed out, with all of these issues that we now have to decide to try to resolve today. Commissioner Gray on page 2259, starting at line 18. So what I'm left with in consideration of this matter is, how can the commission trust the testimony filings conformance with commission's orders? Asks Mr. Jordan, if you were doing this all over again, what would you do different? Mr. Jordan replies, Commissioner Gray, one of the items that the company has implemented to catch this sort of thing again is to go through and checklist what's in a rate filing against those minimum filing requirements, and to make sure that we've got 2 columns of boxes and that both columns are being checked off. Each person will have an assignment, and one of the ones that will be there will be to make sure that those minimum filing requirements are met. That's just part of it. I won't go further. There are other mentions of it. So if the commission, having read Mr. O'Brien's version of the order, agrees that this is only about one minimum filing requirement, then staff will accept that. If the October 6th deliberations were concerned about and sought to warn the company about violations of minimum filing requirements because of the broader picture, then I suggest that staff's version, of which I have a red line and a clean copy, 10 copies of each together, that would be more appropriate. So I will leave it at that, and the commission can enter which order is more appropriate.
Thank you, Mr. Walsh. Commissioner Gray.
Thank you, Mr. Chair. So, Mr. Walsh, do we have a copy? Have we seen Mr. Walsh, sorry, have we seen this version of the staff's language yet? I'm just yes or no, please.
No.
No.
For some reason, that did not, and I'm not sure if what was filed as far as the agenda link did not include staff's proposed edits.
Is there a reason why?
I don't know internally with all that was going through with the edits. I do not know why.
Okay, one last question, Mr. O'Brien. This is pending order number 9863 in front of us. Is that?
Commissioner Gray.
I see a 9893 and a 9863. Which of those is under discussion right now?
Right now, it's 9893, but if you accept 9893, then we would go to revised order number 9863, and it would follow that you would accept that also. But I would suggest 2 different votes on these 2 orders.
What's the difference between these 2 now on this page?
All right,
Please.
so order 9893 is a brand-new order that memorializes your vote from the last meeting, and that vote was to remove the reprimand and the requirement for a remediation plan and insert a warning
moving forward. That's 9893. So since 9893 removes the reprimand and the directive for a remediation plan, we then go back to 9863 that had those items in it and revise it consistent with 9893. Because 9893 revises Order 9863.
As far as I can tell, Commissioner Gray, the only difference is an S. Do you want to have it plural? Or do you want to have it singular? And to speak for myself, I think it should be plural. Commissioner Drexler?
So it's kind of a loop that you're saying, Mr. O'Brien, that we had 9863, 9893 memorializes the discussion that we had on the 6th, and then 9863 is revised, but then why do we need 9893 if we're revising 9863? Separate issues because it's memorializing the discussion, and 63 removes the, then 9893 is revising an order that's being revised. It seems like a loop to me. Because if you accept the revised proposed order number 9863, why do you have to then revise it?
Well, it's to add the warning.
Okay, I got it. Yep, I understand. Thank you.
So, Mr. Chair, may I?
Sure.
Commissioner
Again,
Gray, I'm
I'm-
sorry to interrupt. Would you like a copy of
Not
what
not
staff
yet,
proposed?
not yet,
Okay.
thank you. I'm a little confounded in some ways because I can see in 9893, if I do a search on 9863, minimum filing requirements does not appear at all. So that's where my confusion is. If one is a revision of the other, I can't, unless I have the wrong version of 9863. I don't see minimum filing requirements in 9863 at all.
Commissioner Gray, that was one of the reasons why you decided to remove the reprimand, because the MFRs were not mentioned in 9863. So there's no reason for us to go back and add MFRs to 9863. I suppose from a procedural standpoint, if it pleased the commission, we could do away with 9893 and revise Order 9863 further to add the warning in.
Mr. Walsh, is that where you're headed in this discussion, please?
Well, that would work for staff if staff's version of, in particular, ordering paragraph number 4 from Order 9893 is made a part of that 9863. Gets a little confusing here. And we simply changed it to read that the commission hereby issues a warning to Delmarva that if it fails to, the change here, to comply with the MFRs in future filings, Delmarva will be subject to penalties. And we took out, instead of, we took out the part that reads, fails to, omitted or deleted, disclose departures from prior orders and future filings as required by MFR 2.1.5, because it is staff's belief that it is not a warning limited to 2.1.5. It is a warning to comply with the MFRs, all of them, in future filings.
Well, I distinctly recall the warning in the record from our last hearing. And so I think it would be appropriate to embody that language in whichever order we vote on. But now my question to you, Mr. Walsh, would be, what would you number that order?
Well,
9873.
I suppose it could be, since we have not entered and there is a proposed revised Order 9863. If the commission puts on the record and then Mr. O'Brien is willing to, and the parties agree, that 9863 can have the language I just quoted from ordering paragraph number 4 of 9893, I think we've met the, included both.
Mr. O'Brien, do you have a position as to whether or not to adopt this language as proposed?
Well, my position is the commission's position, and if the intent was for all the MFRs, then that was the intent. I mean, when I hear the transcript and a commissioner refers to this happening again, to me that means the failure to flag a deviation from a prior order. And when Commissioner Gray refers to conformance with commission orders in the transcript, to me that's MFR 2.1.5 and no other MFR. So to me, the substance of the entire discussion revolved around 2.1.5. That is whether or not a company flags or notifies staff that its request includes a deviation from a prior order. That was the meat of the discussion. So to me, I interpreted the motion and the vote to apply only to that, since there was no discussion of any other MFR and whether a warning was warranted for all the other MFRs. That was my reasoning, but certainly today, we're on the record, we're in public. If the commission wants the warning to apply to all the MFRs, then we would adjust the order accordingly.
It doesn't seem to me, Commissioner Gray, to be real good public policy to pick on one of the MFRs. It would, in my humble opinion, we should make the policy applicable to all of the MFRs. I mean, why come back and have the same runaround just because we're talking about a different one of the minimum filing requirements?
You're reading my mind, Mr. Chair.
So that's why I said to you that I think that the S is the only thing I'm concerned about, and I think I like the broader version as articulated by staff through Mr. Walsh. And I would ask if anybody else agrees with that we have a motion and resolve this issue.
If I knew which order to call
Leave
this,
the numbers
Mr.
out.
Chair.
I think Mr. O'Brien and Mr. Walsh are perfectly competent to come up with the correct numbers.
I'd like to move that the commission adopt an order as revised by Mr. Walsh's staff proposal, which will, I believe, memorialize the October 6th vote to grant Delmarva Power and Light petition.
Do we have a second
May-
question?
May I just
We'll
say
get
that
the second first, and we'll have
Okay,
questions.
sorry about that.
Second the motion.
Commissioner Drexler.
Yeah.
Chair Winslow, again, this is the case where Commissioner Conway abstained on an earlier.
Oh, okay.
So I'm not going to
But
second,
this-
but yet, but I just want to say
This
that
happened October 6th.
it's specific to MFR 2.1.5. That is the violation that we discussed, and that is the violation that we issued a reprimand on. So it was specific. I don't know if it would change that if we took that paragraph that specifically says on the one hand, you know, the Delmarva's violation and its delay is a departure from the settlement agreement, and then go back and say at the end, or change the end of that paragraph to say, the commission voted to remove 9886 from order 9863, its reprimand and the requirement, et cetera, regarding future violations of MFR 2.1.5, and change that to MFR 2.1.5 and any other violations of MFRs. Does that change the order?
I think
Or the
what the commission did,
intention.
Commissioner Drexler, I think the commission made a particular finding with respect to one MFR.
Right.
But going forward, we want to have a general public policy that's applicable to all of the MFRs, so that when this issue comes up again, we're on a record as already stating that whichever MFR it is,
Right.
if you don't obey it, then you suffer the consequences. So I think that's.
Right, but the language wouldn't change. I don't think we changed the whole paragraph because it is that, the only one that was violated was 2.1.5. So we're issuing a warning, but we're issuing a warning regarding future violations of any MFRs. So I wouldn't change it throughout the entire order. I would just change like that one end of the paragraph where it says future violations of any MFRs or MFR 2.1.5 and any other. But there's not a reprimand of any other. The reprimand is very specific to that MFR. But the recommendation or we're warning about future, but the reprimand is specific to that one.
I think you're absolutely correct. Mr. Walsh, you.
Yeah, and I'm,
Sorry, Mr. Chair, may I please, a point of clarification? I think we're discussing a warning and not a reprimand.
Yeah.
I just want the record to reflect that.
Right, so the reprimand's 2.1.5, the warning is.
I don't think we have a reprimand on the table, Commissioner Drexler.
Well, we're removing the reprimand, so, okay, so then the warning would be any violations, yeah. Because we removed it, okay.
may I, Chairman,
Please.
just to restate what ordering paragraph 4 states in staff's revision, and acknowledging that there's no longer a reprimand, it is a warning. And it will read that the commission hereby issues a warning to Delmarva that if it fails to comply with the MFRs in future filings, Delmarva will be subject to penalties including. That's the change.
Your Honor.
This is, Mr. Chair, this is the motion that I have made based on Mr. Walsh's revision as just stated.
And I second.
Is there any further discussion? All those in favor signify by saying aye.
Aye.
Abstain.
Aye.
The motion carries. And that order will be with us at our next commission meeting. Ms. Emerson, do you want to let us know what happened with respect to the town of Milton? Is there anyone here from the town of Milton?
I am, Mr. Chair.
Okay. What do we have on numbers 1 and 2?
Thank you, Commissioner Chairman. Again, Courtney Emerson from Artesian Wastewater Management, Inc.
Would you please pull the microphone right up because otherwise we
Certainly.
won't hear you. Thank you.
Certainly. Again, Courtney Emerson from Artesian Wastewater Management, Inc. And shall I presume that you would like to proceed with agenda number 1 and 2 now?
Yes, please.
On July 14th, 2021, Artesian filed its application requesting a wastewater CPCN for the parcel we refer to as Sandhill 1900. And on August 12th, 2021, Artesian filed its application requesting a wastewater CPCN for parcel that we refer to as Sandhill 1200. And I will refer to those jointly as the proposed service area. And those are agenda numbers 1 and 2 respectively. In each of those applications, Artesian has satisfied its statutory obligations under 26 Del Code 203D to obtain the requested CPCNs, including but not limited to receipt of a petition requesting wastewater service and demonstration of its financial, operational, and managerial capacity. As staff indicated in its memo, Artesian Wastewater included the required documentation in its application, and staff identified no issues with the application. As such, we contest that the application should be approved over the opposition filed by the town of Milton. As to the town's opposition, the town states that the proposed service area is in an area identified in the town's 2018 comprehensive plan as a future growth and expansion area, and that on or about June 17th, 2021, the owner of the proposed service area, Sandhill LLC, filed an annexation withdrawal petition with the town. To our knowledge, and according to public record, the annexation has not yet been completed. The town further stated that the town receives wastewater and sewer utility services from Tidewater Environmental Services, Inc., TESI, under CPCN 07WW021, issued in August 2007, and that the town currently holds a non-exclusive CPCN for the proposed service area. The commission should approve the CPCNs for Sandhill 1200 and 1900 over the town's opposition for at least the following reasons. The town of Milton is not a provider of wastewater services, and therefore we suggest lack standing to object to the applications. The proposed service area is not in the town, and the proposed service area's designation as part of the future growth and expansion area, and the proposed service area's inclusion in a petition for potential annexation to the town do not confer standing on the town to object to the application. Artesian Wastewater filed a written response, which you should have. In there, I go into further analysis of, in the matter of the application of Artesian Wastewater Management, that's docket number 07WW002.
Could you say that again?
Certainly. 07WW002. Specifically, order number 7209, dated June 19th, 2007, denying the town's objection to Artesian's application for a CPCN for parcels outside the town of Milton. The order said that those parcels were not subject to the 203D bar. Moreover, as stated in staff's memo and is more fully described therein, pursuant to 07WW021, order number 7244, the commission has previously granted to TESI authorization to provide its wastewater public utility service to all properties located as of June 7th, 2007, within the town's corporate boundaries. The parcels in these two CPCN applications were not within the town's corporate boundaries as of June 7th, 2007, nor are the parcels currently in the town's corporate boundaries. And as I stated, the annexation is not complete. In the staff's memo, they report that the town special review committee the annexation is still in a review by the town's special review committee, and it will not be before Milton's Town Council until February 2022. Moreover, in the First Amendment to the town's wastewater service agreement with TESI, executed on June 13th, 2007, the town acknowledged and agreed that if Senate Bill 77, as amended by Senate Amendment Number 2, was enacted into law, which happened by the governor's signature on June 28th, 2007, TESI may not be the sole provider of wastewater services for the growth area. Finally, as indicated in staff's memo, Artesian has satisfied its statutory obligations under 26 Del Code 203D to obtain the requested CPCNs, including but not limited to receipt of the petition and demonstration of its capacity. And as such, we would request that the commission grant the two CPCNs over the objection of the town of Milton.
Thank you very much, Ms. Emerson. Mr. Walsh?
Thank you, Chairman and Commissioners. Ms. Emerson did accurately reflect staff's memo, and while the town is not here, we did recognize the June 7, 2007 cutoff date for being within the boundaries, not in the boundaries, and it did not appear to be within, and therefore not exclusive, and therefore staff supports entry of Order 9862 in this matter.
Are we discussing 9861, or not, sorry, 9891 at the same time?
Yes, Chairman, thank you.
And-
I'm sorry, it's 9891 and 9862.
Yes.
Correct.
Thank you.
I thought
Staff's-
Mr. Walsh only
yep.
addressed the one, not the other. I'm sorry.
I did, and I apologize. Staff's position is the same as the vote for the same reasons stated in the memorandum. We support both forms of order. 9862, order number 9862 for docket 210536, and order number 9891 for docket 210587.
Thank you, Mr. Walsh. Ms. Iori?
The public advocate takes no position in these two matters.
Thank you. And the status of Mr. Mandalas?
I'm here.
Oh, I'm sorry, I apologize.
May I be heard?
When you said someone from the, yes, please.
Thank you. Good afternoon, Mr. Chair and members of the commission. My name is Glenn Mandalas. I'm an attorney with Baird Mandalas Brockstead, and I do represent the town of Milton in these matters. I have to ask a procedural question initially. I had understood that these two requests had been, I understood there was been a request for a continuance in these two matters.
One of the matters was rescheduled for the maximum period of time we're permitted to do it under the law, and the other one has not had such a continuance.
Understood. So let me explain as a matter of background. The reason the town objected to these CPCN applications is kind of an interesting set of facts. We, the town, is obligated to Tidewater Environmental Services, Inc. contractually. They are the wastewater services provider for the town. Part of the agreement that we are in with TESI requires that we support TESI's ability to be the town's exclusive service provider, not only within the town's borders, but also within its expansion area. These areas that we're talking about are within the town's expansion area. So when the CPCNs were initially filed, we, the town, was contacted by TESI and asked if we are going to take a position on the CPCNs. Recognizing our contractual obligation to support TESI in its efforts to service the town and its expansion areas, we took a position adverse to these applications, not knowing all along that in the background, TESI and Artesian were working together on a deal, a stock purchase agreement, so that Artesian would then become the parent corporation of TESI. Once that deal was announced, the town reached out to TESI and said, through its attorneys, and said, what is your position? Should we continue to object to these as we're contractually obligated to do? And we didn't hear anything back. So we're here in kind of a unique situation in that we feel like the town is contractually obligated to object because Artesian is not the exclusive provider for the town. But recognizing that now a transaction has been announced between TESI and Artesian, I find myself in a kind of awkward position trying to figure out what position to take. So I guess the town's bigger concern is the Artesian TESI Section 215 transaction that you're going to hear later today, and not so much these CPCNs. I think that other matter will resolve what happens here. So it is with somewhat of a non-position that I'm speaking. I just want you to have sort of the background as to why the town objected in the first place.
Thank you very much. Appreciate that input. Do any of the parties have any questions of any of the other parties? Any commissioners have any questions of the parties? Commissioner Gray.
Mr. Chair, I have a question, Mr. Walsh. So it was mentioned there's an exclusive contract between the town and TESI. In making your determination and proposal for the commission, have you reviewed or had an opportunity to see this contract?
The contract, if we're talking about the same one, and I believe we are, was filed Saturday. Is that the same contract?
So, Mr. Walsh, the contract is Exhibit A to the town's petition to intervene in the Section 215 matter. Filed, I think Friday, although because we had to provide a link rather than the actual documents, I don't think anybody actually probably saw it till the weekend.
So if this contract is a part of the record, what is staff's position having reviewed that contract with respect to the case that the attorney here is making?
Well, if the commission determines that that contract supersedes any ability, whether those subject parcels are, or I shouldn't say supersedes, controls, determines whether they are exclusive or not exclusive, that could change staff's position. We were in the position of having, not having that contract, and that memo was created, and the proposed order that I drafted were based on the information that we had at that time, and it really hinged on whether it was within the boundaries before June 7th, 2007, and they were not. So therefore, we found that they had met the requirements under Section 203. So we are now here today also with docket 210707 to be heard, which has in its record that contract. So it's a little troublesome and it's a little confusing, frankly, to get our heads around this entire thing, because there may be contractual rights there that cannot be changed by way of a commission order. But I don't know that until the parties present their arguments, if that is to occur today, in docket 210707.
Mr. O'Brien, does an exclusive contract, should it have the appropriate terms and conditions, prevail over a CPCN from this commission?
No, Commissioner Gray, Bill O'Brien, Commission Counsel in this matter. No, these parcels, neither Milton nor Tessie had a CPCN for these parcels going into today. So they can't contract amongst themselves as to who's going to serve it amongst themselves. So Artesian came in, they checked all the boxes under 203D, and now that application is before the commission. That contract, I mean, other than obligating the city of, or the town of Milton to be here today, I don't see its relevance whatsoever to whether you grant Artesian the CPCN. I mean, at one point, they mentioned Milton having a non-exclusive CPCN for this area. The commission does not grant non-exclusive CPCNs, so I'm not sure exactly what they're referring to. I believe what they're referring to is that it's part of their comprehensive plan. But as Artesian mentioned before, the commission has already made a finding that Milton's comprehensive plan does not establish its service area rights to that property. The only property they had service area rights to were within their town limits, and they don't have those anymore because they transferred them to Tessie.
I mean, one point of clarification, did you say there's no CPCN sitting on these two parcels right now?
That is correct.
Okay, no further questions, Mr. Chair.
Any further questions? Does any commissioner have a motion to make?
I'd like to move that the commission adopt orders number 9862 and 9891 as submitted.
Second the motion.
Mr. Mandelis, thank you for coming in to let us know about the city of Milton's concerns. Obviously, the state has submitted a memo to us indicating that all factors under 203 have been satisfied. I think that you sort of agree that we need to proceed and go forward. And I would just say that I support the motion, and we'll be voting for the motion. Any other comments?
Could I respond just for a moment to that, Mr. Chair? I just wanted to say I actually agree with your council's interpretation and analysis of the law. Again, our only view is that we had a contractual obligation to support Tessie's efforts to serve this area. So I think as a matter of law, your council is correct that you can grant this CPCN.
All those in favor signify by saying aye.
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 Commissioner-
Aye.
So that's all five. Are there any opposed, any abstentions? Thank you all very much.
Thank you.
I believe we're on number 5 now in the matter of a request for approval of Delmarva Power and Light's 2022 Energy Efficiency Surcharge Rider. Ms. Kurtz-Compton?
Thank you, Chair Winslow and Commissioners. Again, Dawn Kurtz-Crompton appearing on behalf of Delmarva Power and Light Company. You have in front of you for your consideration order number 9898, which would open the docket for Delmarva's 2022 Energy Efficiency Surcharge Rider Rate. On September 30th, 2021, Delmarva submitted revised electric tariff leaf number 127, which proposed a new rate of 0.000792 cents per kilowatt hour, which was a decrease from the prior year's rate of 0.000828 cents per kilowatt hour. Delmarva requests that the Commission approve the tariff rates set forth in leaf number 127 on a temporary basis and subject to refund following review and final approval by the Commission. I thank staff for preparing the proposed order and for allowing Delmarva the opportunity to comment. We are in agreement with the form of order presented to you today, and we respectfully request that the Commission enter or approve Order 9898 as submitted. Thank you.
Thank you. Mr. O'Brien?
Thank you, Chairman Winslow and Commissioners. Bill O'Brien on behalf of staff. Staff agrees with Delmarva's summary of proposed order number 9893 and requests that the Commission enter the order. Thank you.
Ms. Ivory?
Thank you, Chairman Winslow and Commissioners. The Public Advocate supports proposed order number 9898. Thank you.
Thank you. Commissioners, any questions? Commissioner Drexler?
I'd like to make a motion to approve proposed order number 9898 as presented.
Second the motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Any abstentions? The motion carries. Thank you very much, Ms. Dawn Kurtz-Crompton. Number 6 is in the matter of the petition of the Public Service Commission staff and Delaware Division of the Public Advocate to establish a regulation for distribution system investment plans for Delaware electric and natural gas utilities. Mr. Walsh on behalf of staff.
Thank you, Chairman Winslow and Commissioners. Tom Walsh on behalf of staff. This is the acknowledgement order for Delmarva Power and Light's gas regulations, specifically, I shouldn't say gas, right? Their proposed ISR plan under 26 Delaware Administrative Code Section 8003, and I'll refer to those as the regulations. And Order 9899 sets forth the dates on which the pertinent information was filed by the respective parties. On August 27th, Delmarva submitted its 2021 final gas ISR. On September 10th, the Public Advocate's Office and staff filed joint comments. And on September 20th, Delmarva filed reply comments. And this order, as it states in the first ordering paragraph, this is pursuant to Section 7.5 of the regs. This is a Commission's acknowledgement that Delmarva's final 2021 gas ISR plan was submitted in accordance with the regulations, and of course in ordering paragraph number 2, it recognizes that any party may challenge Delmarva's attempt to recover amounts spent in its distribution system, spent on its distribution system and services in a future rate case. So with that, and this has been circulated to the parties, staff respectfully requests that the Commission enter Order 9899.
Thank you, Mr. Walsh. Is that Mr. Nutter down there?
It is, Mr. Chairman, and I think I may have jumped the gun by coming to the bench here because I'm here for Chesapeake on behalf of Ms. Orr, who's unavailable today, and they are Order 9900 under subsection B of Agenda Item 6, but with your permission, I can stay or I can return to my seat, whichever pleases the commission.
I think if you just stay there, everybody will be happy.
Thank you.
Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The Public Advocate supports the proposed form of order acknowledging Delmarva's ISR plan for 2021. Thank you.
Thank you. And Mr. Nutter, Chesapeake has no objection to the order, is that correct?
No, sir.
Since you're there, we got to put you to work.
No, sir, no objections.
Commissioners, any questions?
Move we adopt order
Well,
9899.
I apologize. Mr. Jordan?
Yes, good afternoon, Your Honor. Brian Jordan here on behalf of Delmarva Power and Lights to discuss Order 9899, and thank you for the opportunity to discuss it. I wanted to first thank Mr. Walsh for preparing the draft order and getting it together, and I also wanted to extend my gratitude to DPA and to staff and their consultants. As we worked through this over the summer, the parties met together to discuss Delmarva's gas ISR plan. It was the one that ultimately was filed. And again, I just wanted to thank staff, their consultants, and the DPA, and that Delmarva Power and Light does support Order 9899. Thank you.
Thank you. Commissioners, any questions? May we have a motion, please?
Move we adopt order number 9899 as presented.
And I second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 All four
Aye.
said aye, and Commissioner Korea is an aye as well. The motion carries. Thank you all very much. Number 7 is in the matter of the application of Chesapeake.
We have B on that.
B, I guess
9900.
Mr. Nutter,
Yeah.
it wasn't enough. Order number 9900, Mr. Nutter.
Thank you, Mr. Chairman. Good afternoon. James Nutter with Parkowski, Gherkin, Swayze again on behalf of Chesapeake Utilities and standing in for Ms. Orr. Before you is proposed order 9900, which will acknowledge that Chesapeake's 2021 gas infrastructure safety and reliability plan has been filed and is consistent with the newly promulgated Regulation 8003, which took effect last October. Chesapeake filed its ISR plan April the 30th, and then thereafter had meetings with staff and DPA, as well as their consultant. The consultant for staff and DPA has reviewed and offered comments with respect to Chesapeake's plan and suggested improvements for improving the reports going forward in future years. This was the first year that Chesapeake was required to file an ISR plan, and so they appreciate those comments and will take those into consideration moving forward to streamline future reports. But otherwise, the consultant recommended no major changes and indicated that the ISR plan was complete in material respects, and we ask that you approve Order 9900. I'm happy to answer any questions that you may have.
Thank you, Mr. Nutter. Mr. Walsh?
Thank you, Chairman and Commissioners. Mr. Nutter did a wonderful job representing that order.
He's not quite as good as Lindsay Orr, though.
Certainly not.
Staff supports entry of order number 9900 in this matter, which is an acknowledgement order. And of course, as before with Delmarva's order, there is the reservation for any party to challenge expenditures on the distribution system and services in any future rate case. So unless Mr. Jordan has any argument to present on this one,
Ms.
I will
Iori?
stand.
Delmarva has no opposition, Your Honor.
Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The DPA supports proposed order 9900, acknowledging Chesapeake's 2021 ISR. Thank you.
Thank you. Commissioner Gray?
I'd like to move that the commission adopt order number 9900 as submitted.
Second the motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any opposed or any abstentions? The matter passes. Thank you, gentlemen
Thank you, Your Honor.
and lady. Okay, now we have number 7, in the matter of the application of Chesapeake Utilities Corporation for approval of a change in its gas sales service rates. And we have Mr. Nutter on behalf of Chesapeake.
Thank you again, Mr. Chairman and members of the commission. James Nutter with Parkowski, Gerken Swayze, standing in for Ms. Orr on behalf of Chesapeake Utilities. Before you is proposed order 9902, which would increase Chesapeake's GSR rates for 3 classes for usage on or after November 1st, 2021, and which would also waive the 60-day notice requirement in Section 304 of Title 26 for rate changes, based on a finding that good cause exists for the waiver. By way of background, Chesapeake filed its annual GSR filing on August the 31st of 2021 to be effective for usage occurring after 11/1/2021. And on September 15th, the commission entered Order 9880, which approved the rate and changes and tariff revisions Chesapeake initially proposed, subject to refund and pending the commission's review and final determination. Subsequent to Chesapeake's initial filing, commodity prices for natural gas have increased by more than 30%. There are percentage thresholds in Chesapeake's GSR tariff that are intended to protect against over-collections and under-collections related to the cost of natural gas, and it soon became apparent to Chesapeake that it would exceed the 6% under-collection threshold very early in the new annual GSR period. Consequently, on October the 8th, 2021, Chesapeake filed a supplemental application to address the commodity price increase and prevent against or mitigate the under-collection. Chesapeake is requesting that the commission waive the 60-day notice and allow the rates to take effect so that increased gas costs are spread over greater volumes of billing units during the winter heating months, which will avoid larger future increases to make up for the under-collection. Proposed Order 9902 will adjust Chesapeake's rates and waive the statutory notice requirement. And again, all this was subject to refund and pending the commission's final review and determination. Order 9902 also establishes a revised intervention deadline and directs Chesapeake to publish notice of the supplemental filing the week of November 8th. There are set forth in the order a breakdown of expected increases for current usage among customers within the various rate classes. Chesapeake's does have the submitted testimony of Maria Kozel, and she's here to answer any questions, and I'm happy to answer any questions as well, but if not, we ask the court to approve the proposed Order 9902, and I do thank the commission staff for preparing the draft order.
Thank you, Mr. Nutter. Mr. Walsh.
Thank you, Chairman and Commissioners. For all the reasons stated in Mr. Nutter's accurate recitation, we support entry of Order 9902.
Thank you, Mr. Walsh. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The DPA supports proposed order number 9902. Thank you.
Thank you. Commissioners, any questions, or may we have a motion?
Move we adopt order number 9902.
I
as
second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any
Aye.
opposed? Any abstentions? The motion carries. Thank you, Mr. Nutter. Number 8 is in the matter of the application of Artesian Water Management, Inc. and Middlesex Water Company for approval of the sale and acquisition of Tidewater Environmental Services Incorporated. And we have a proposed order 9911 and 9909 before us. And we have, once again, Ms. Emerson from Artesian, who I believe is supposed to explain this application.
Good afternoon again, Chairman and Commissioners. Courtney Emerson on behalf of Artesian Wastewater. I do want to take this opportunity to introduce, though you are all very familiar with them, I have here with me Dave Spake, who is the president of Artesian Wastewater, Nikki Taylor, who's the president of Artesian Water Company, and then Diane Taylor, who is the CEO of Artesian Resources Corporation. Would the commission and staff like to hear the Town of Milton's request to intervene before we proceed with the substance of the application?
Yes.
Yes.
Thank you. I will defer to counsel from Middlesex and Tessie. I have, Jamie Nutter's here, and then Jay Cooper from Middlesex.
Thank you, Mr. Chairman. On your consent agenda today was an order approving Mr. Cooper's admission pro hoc vice in this matter. Mr. Cooper is General Counsel for Middlesex Water Company, and he'll be handling the matter before the commission this afternoon.
Mr. Cooper.
Good afternoon, Mr. Chairman, Commissioners. Good to be back before you. I am here on behalf of Tidewater Environmental Services, Inc., or TESI, as you know, a subsidiary corporation of Middlesex Water Company. Present today is the president of TESI, Mr. Bruce O'Connor, is here today, as well as Kirsten Higgins, also of TESI. And I will be here to respond to the intervention motion for Milton.
Thank you, Mr. Chair, members of the commission. My name is Glenn Mandalis, and I'm attorney with Baird Mandalis Brockstead. We have offices most closest in Dover here at 6 South State Street. The town of Milton does move to intervene in this proceeding predominantly because the town's interests are simply not represented in the proceeding. And in fact, the town's interests are adversely affected if this transaction were to proceed. I'll have a lot more to say about it should you grant me the privilege of intervening, but to say the least, the contract that I mentioned earlier between the town of Milton and TESI includes a number of different things, but boiled down to its essence, the TESI was to become the exclusive wastewater treatment provider of Milton. And obtain significant impact fees as it did that, and obtain impact fees that were north of $2 million that the town was holding at the time this deal was consummated in 2007, in return for TESI building a new wastewater treatment plant at a location on Sam Lucas Road. The contract evidences that, addendums to the contract evidence that. Importantly, as part of that construction of
Mr. Mandalis, will you please restrict your comments to the motion to intervene, the merits of that motion, and we can discuss the merits of the case after that's decided?
Sure, I appreciate that, Mr. Chair. So the interests that we have in this proceeding are that, first, that TESI meets its obligations under our contract. Secondly, that the Sam Lucas facility be constructed. Third, that the impact fees that have been collected by TESI in connection with the contract either be properly used or reimbursed. Next, that the applicants or TESI dismantle the Broadkill plant in Milton, and that Milton's residents not be required to pay increased rates as a result of the transaction. Milton's interests are simply not adequately represented by the parties to the transaction. They don't represent Milton's interests, and in fact, as I said, they're adverse to Milton's interests. Simply stated, if the contract is consummated, Milton will not have had an opportunity to make its case before you that there will be contractual obligations that will not be observed, and Milton will be left holding the bags basically to handle some of those activities that we believe TESI is obligated to do. So basically what I'm saying is that the town is here before you, indicating that if this transaction is approved, it'll pave the way for TESI to renege on contractual obligations, and we'd like a forum or at least an opportunity to present to this forum the reasons why we think the transaction will allow for those things to occur that certainly are not in the public interest.
Mr. Walsh.
On behalf of staff, we support Town of Milton's petition to intervene so that the record can be fully examined before the commission.
Thank you, Mr. Walsh. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The DPA likewise supports the Town of Milton's petition to intervene for the reasons expressed by Mr. Mandalis and Mr. Walsh.
Mr. Cooper?
For purposes of a full record, I do not oppose the petition to intervene.
Mr. Nutter?
Mr. Cooper speaking for Middlesex.
We'd like to hear from you, Mr. Nutter. Commissioners, do you have any questions? We have a motion, please.
I'd like to move that the town of Milton be allowed to intervene in this matter.
I second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 The motion carries. Mr. Mandalis, you'll have your say in turn.
Thank you, Mr. Chair. Thank you, Commissioners.
We have proposed order number 9911 and 9909. And once again, we have Ms. Emerson.
Good afternoon again. On September 7th, Artesian Wastewater Management, Inc. and Middlesex Water Company, which are referred to jointly as the joint applicants, filed our application seeking approval from the Commission for Artesian Wastewater to acquire control of TESI, Tidewater Environmental Services, by purchasing all outstanding shares of TESI's common stock from Middlesex, its parent company. This transaction is a straightforward stock purchase agreement and results in TESI being the same group both before and after. The applicants are Artesian Wastewater Management, Inc., a Delaware corporation, wholly owned subsidiary of Artesian Resources Corporation. Artesian Wastewater is a commission-regulated public wastewater utility which operates wastewater treatment, collection, and disposal facilities, serving residential, commercial, industrial, governmental, municipal, and utility customers, primarily in Sussex County, Delaware. As of August 31st, 2021, Artesian Wastewater was serving approximately 3,085 residential and commercial customers in Sussex County. Middlesex Water Company is a New Jersey corporation that operates regulated water, utility, and wastewater systems in Delaware and New Jersey. Middlesex is the parent company and sole owner of TESI, owning all 100 certificated shares of TESI's common stock. TESI is a Delaware corporation, a wholly owned subsidiary of Middlesex, and operates wastewater treatment, collection, and disposal facilities, serving residential, commercial, industrial, governmental, municipal, and utility customers, primarily in Sussex County. And as of August 31st, 2021, it was serving 3,635 customers. Pursuant to the stock purchase agreement, which was dated August 27th, 2021, between Artesian Wastewater and Middlesex, Artesian Wastewater intends to purchase 100% of TESI's issued and outstanding common stock. The purchase price of the stock is $4,300,000. That price is based on TESI's rate base as of June 30th, 2021. Artesian Wastewater intends to finance this transaction through existing short-term lines of credit and plans to secure longer-term financing after the transaction is completed. As you know, Artesian has elected to defer its application for approval to merge TESI into Artesian Wastewater upon consummation of the transaction, and will instead defer that application until a later point in time. Artesian will operate TESI as a wholly owned subsidiary post-closing, and TESI's customers will be charged based on TESI's rates and billing cycles as approved by the Commission, which orders are in 2011, 2012, and 2013. Any changes to TESI's wastewater service rates will require Artesian Wastewater to file an application with the Commission seeking approval of such changes. We submit that this transaction is in the public interest, including that of the residents of the town of Milton, and that the agreement is in accordance with law and is for a proper purpose. It is in the public interest to have an experienced public wastewater utility assume the responsibility for the service territory TESI currently serves. TESI service territory is largely contiguous to and adjoins Artesian Wastewater's service territory. Dave Spade here has a map of the two service territories. This is an exhibit to our amended 215 application.
We have a fun drive too, tomorrow night, so this is for purposes
We do.
of visual.
And there's nothing specific to point out necessarily at this time on this map, other than to show the contiguous nature of the service territory.
The service station is there, and theirs is here. So it's right next to each other.
Thank you.
We had a plethora of pictures included in our material.
We
A lot of
hope
different
it,
colors.
It broke up the reading for you.
Yeah.
If the transaction is approved, as you can see by this map, it will ultimately allow Artesian Wastewater to interconnect the applicant's various wastewater systems so that both operational and financial efficiencies are realized. Specifically, integrating the applicant's service territories and facilities in Sussex County and existing interconnection agreements with Sussex County's sewer infrastructure will assist in the eventual regionalization of the system to the financial benefit of ratepayers throughout the county. Without timely approval of this acquisition, the applicants would each need to construct new wastewater treatment plants in the Milton area. Tessie is currently in need of replacing its wastewater treatment facilities in Milton and has solicited bids for the replacement. The lowest bid has an estimated cost of $23.4 million. Almai's Surf wastewater plant, for which we already have a I'm sorry.
Can you say that again?
Yes. Artesian Wastewater's SURF, which is SRRF, wastewater plant, for which we already have a draft construction permit, will provide central sewage treatment for an approximately 94 square mile area in Sussex County, including areas surrounding the town of Milton. The plant is planned to be operational in March 2023. The estimated cost to build Artesian Wastewater's plant, additional force main and pump station, renovation and construction is $13.9 million, which is approximately $10 million less than the proposed plant that Tessie has received bids for. Upon completion of Artesian Wastewater's plant, we'll have the capacity to treat approximately 625,000 gallons per day, which is more than sufficient to serve Tessie's existing and future customers, including the residents of the town of Milton. The elimination of the need to construct two plants would be a savings to the town of Milton's customers. If Almai's acquisition of Tessie is not, if Artesian Wastewater's acquisition of Tessie is not approved, however, the approximately 1,680 customers currently served by Tessie in the town of Milton will bear the full cost of the $23.4 million Tessie plant, rather than bearing only a proportionate share of the cost of Artesian Wastewater's surf treatment plant. The $13.9 million cost of Artesian's plant would be spread across customers throughout the county. The elimination of, on a per gallon basis, the Tessie plant would cost Milton customers $66.85 a gallon, cost that is 3 times greater than the $22.24 cost per gallon to build Artesian's plant. This cost differential stems from a difference in the disposal methods between the two proposed plants. Milton's plant is proposed to discharge into the Broadkill River, requiring it to use a more expensive membrane system. Artesian's surf plant will use a modified Bardinfo system, which is significantly cheaper.
Modified, I'm sorry.
Bardinfo, B-A-R-D-E-N-P-H-O. The agreement will not impair the ability of Artesian Wastewater to provide wastewater services to its existing customers. Shortly after closing, Artesian Wastewater will send notification letters to customers explaining the change in its wastewater service provider and how the change will affect them. Tessie, to our knowledge, does not have any permanent employees, and the contemplated transaction will not result in the loss of any existing jobs. Again, we want to just reiterate that the timing is of the essence, as the parties have agreed to complete the transaction on an accelerated basis due to contractual arrangements proposing the surrounding the proposed construction of the Milton plant if needed. Defer to Jay or Jamie?
I don't have anything to add on Ms. Emerson's well-done summary.
Mr. Nutter?
No additional comments. Thank you, Mr. Chair.
I just want to add that we support the proposed order number 9909, which would grant the approval of the 215 application, and welcome any questions.
Mr. Walsh?
Chairman Winslow and Commissioners, I don't have any questions at this time, but I would like to reserve the opportunity to do so following Mr. Mandalis's presentation, because I think that will, if there are questions to be asked, that may give rise.
Ms. O'Rourke, the same position?
Yes, Chairman Winslow, thank you.
Okay. Mr. Mandalis, I have to confess that I'm a great supporter of the town of Milton. I live nearby and I play golf nearby, and I've supported your fire department for several years. It was a very small amount of money. So I have an affection for the city of Milton, which leads me to make the following comments. One is that Tessie is a great company. Sorry you're losing them, but wow, you're getting a great company coming in. Probably, maybe, my guess would be a little bit financially stronger than the one that's leaving. But they're both great companies. We don't have any jurisdiction over contractual rights. We can't make people disassemble plants, do things that they don't want to do. We just don't have that jurisdiction. The only jurisdiction we have is to follow the law and statutes with respect to these matters, which I believe staff and DPA will talk about in a few minutes. I don't mean to throw water on your argument before you start, but from my viewpoint as a friend, I mean, not friend, friend generally speaking, is that it looks like things should be pretty good for Milton. But please, make your arguments that you think are appropriate to the situation here in our jurisdiction for what we can do.
Thank you, Mr. Chairman. I appreciate those comments. Again, Glenn Mandalis on behalf of the town of Milton. I do appreciate those comments. Milton is a special place, and appreciate you putting that on the record. I do think, though, however, that this is an issue of public interest, and I'm going to explain why this transaction, if consummated now and this quickly, is perhaps not in the best public interest. You just heard Ms. Emerson say that the parties have agreed that time is of the essence. Well, time is of the essence because they've agreed that's of the time of the essence, and there's obligations that Tessie would have to build a plant if they don't get this done. So the time of the essence argument, put that aside for a moment, and I'm going to explain to you why I don't think time is of the essence, and why I do think this body has the ability to effectuate a good outcome that is in the public interest. So this story stretches back to 2007, when the town of Milton and Tidewater Environmental Services, Tessie, entered into a contract. The town had a failing wastewater treatment plant. It was located on the town's most cherished natural resource, the Broadkill River. A new plant needed to be built and needed to be away from the Broadkill in a more appropriate location. With limited resources to build a new plant, with no land to do it, the town was in a bind at this point. Tessie, like any good business would, identified an opportunity and struck a deal with the town to solve its problems. Under the 2007 deal, which is Exhibit A to our petition to intervene, Tessie would be the exclusive provider of wastewater services to all of the town's customers at that time, and would be the provider for future customers in the town's growth and expansion areas outside of the town's borders. To make that happen, Tessie would purchase the town's existing plant, infrastructure, and pay a franchise fee. And as of yesterday, according to the town's records, the town is still owed more than $3 million on that transaction. That's not to say that there's anything untoward about that. This was a transaction that was structured over time. I only mention it to say that the town and Tessie are still very much in a contractual relationship. So land on Sam Lucas Road would come under Tessie's ownership under this contract and would be annexed into the town, and that's where the new wastewater treatment plant would be built. The contract's clear in my mind that that's the location that this plant was supposed to be built, that Tessie was obligated to build. Now, to help capitalize the construction of the new plant, the town was obligated to give Tessie roughly $2.3 million in wastewater impact fees that the town had previously collected and was holding. And additionally, Tessie would collect impact fees in the amount of $8,000 for each additional equivalent dwelling unit connected to the system as a means of capitalizing the construction of the new plant. So under this deal, Tessie would get a monopoly on all of Milton's ratepayers, and the town gets a new plant on Sam Lucas Road. Sounds like a match made in heaven. Everybody's marching forward in 2007. Of course, things never move as fast as we'd like them to, and several years go by. Certain amendments are made to the agreement, but the core agreement remained in place. A monopoly on ratepayers and a new plant for the town. So flash forward to 2015, there's an announcement that Tessie and the town were proceeding with the construction of the new plant on Sam Lucas Road. The Cape Gazette has a prominent photograph of Jerry Esposito and the mayor signing the paperwork, and in the article it reads, in 2007, when Tidewater purchased Milton's sewage facilities, an agreement was made between the utility company, I'm sorry. So this is again the Cape Gazette article. It says in 2007, when Tidewater purchased Milton's sewage facilities, an agreement was made between the utility company, town officials, and the property owners, Key Ventures, who were not the property owners in 2007, to annex a parcel on Sam Lucas Road in exchange for a portion of the property to be used for a new treatment plant. So the point is that, look, there was no question that for more than 8 years, the deal was a new plant to be built at the Sam Lucas Road location, and that Tessie had a contractual obligation to do it. In fact, Tessie proceeded to make an application to build the plant, and the site plan has been fully approved by the town. It's true that Tessie has solicited bids, and it seems that the bids have come back at great cost, $23.4 million. But great cost does not relieve one from contractual obligations. So an important aspect of the Sam Lucas facility site plan approval was the requirement that Tessie extend and connect a water main to the Sam Lucas facility. And it's a pretty long run. It goes up Front Street, goes on a portion of Cave Neck Road, and then up Sam Lucas Road. And a copy of those plans that were prepared at Tessie's direction are attached to our motion as Exhibit B. The plans have Tessie's name stamped on the front of them. There's a notation on the plans that say Tessie will construct the water main, and Tessie will then dedicate the water main to the town. This extension and connection were intended to, among other things, service a major subdivision known as Cannery Village Phase 4. Now, Milton granted final approval for the subdivision on July 20th, 2021. And that's well after the construction of the wastewater treatment plan and extension of the water main were approved. So Milton, in reliance upon Tessie's obligation to build this water main, is approving subdivisions that will be along this water main. In fact, Tessie has obtained approval by the Delaware Department of Health and Social Services, the Division of Public Health for the plant and the water main extension. If this transaction that's being contemplated today, the 215 transaction, if it's approved, Tessie will have ducked its contractual obligations to build the plant and extend the water main, will have been enriched with what we estimate to be over $6.5 million in impact fees, and will leave the town saddled with commitments that were based upon Tessie's obligation to extend the water main. That's not in the public interest, to leave the town of Milton with those obligations. Now, with all that in mind, and Mr. Chairman, I appreciate your representation of what your jurisdiction is and what you can and cannot do. I'm not asking today that the commission enter an order saying Tessie needs to extend a water main, or that Tessie needs to get a pipe out of the Broadkill, or any of those specific things. The town isn't unreasonable. We know this transaction will likely be approved, and that, as the chairman said, there are probably some efficiencies to be realized by it. rates may or may not get better, but based purely on the cost of the plants, it seems to look that rates ultimately could be better for the ratepayers in Milton. So we're not asking you to enter some crazy order that that doesn't recognize the public interest or that goes beyond your jurisdiction. What we're simply asking for is that you defer this action so that we can have some time to work with Tessie, who's contractually obligated to us, to work out these things that are of real concern to the town. As they noted, the only thing that's the time of the essence is that they've agreed that the time is of the essence. Well, two contractual parties can agree to anything. The time is of the essence, time isn't of the essence. It's maybe of the essence because of bids that have been solicited and the fact that prices will probably go up if they have to rebid those. But again, it's a contractual obligation that Tessie has. Again, I'm simply asking for a short deferral. It's not in the public interest to authorize a Section 215 transaction when a municipality, the town of Milton, is at your doorstep indicating that authorizing the transaction will pave the way for one of the parties, one of the utilities to the transaction, to breach a contract it has with this municipality. And look, it isn't hypothetical. Tessie representatives have confirmed in discussions we've had with them that they have no intention to build the San Lucas plant or extend the water main. Look, similar to what the chairman said earlier, the town, yes, we likely have legal claims that can be resolved in court, right? We probably have a breach of contract claim. We probably have an unjust enrichment claim. We probably have a detrimental reliance claim. But that's also not in the public interest to force a court action when we think the parties, in good faith, can work this out, given a little bit of time. And that's all I'm asking for today. I thank you for your attention and happy to answer any questions you have.
Thank you, Mr. Mandalis. Mr. Cooper.
A few points, Mr. Chairman. First, council characterized this as time of the essence between two parties. That is not correct. There is a DENREC requirement associated with the existing plant serving Milton in terms of meeting regulations and standards. So the timetable for completeness was agreed to by DENREC. This was not something solely driven by Artesian and Tessie as two parties. That's point number one. Point number two is council's raising basically a contractual dispute. And there are two threshold issues that we really need to tackle before we would even get to the merits. One you've already raised, Mr. Chairman, and that is commission jurisdiction. With all due respect, the Delaware Public Service Commission is not the correct forum for resolution of any contractual dispute or breach of contract between claim that Milton may have with Tessie. That belongs in a court of law. What the commission is being asked to review, consider, and at our request approve today is an application pursuant to Section 215 of a proposed stock purchase agreement. If the commission were to approve that proposed order, Tessie, the corporate entity, would remain intact. It would move from being a subsidiary of Middlesex Corporation, and it would move within the Artesian family of companies. All of the rights and obligations of Tessie, including any contractual obligations, would survive whole into its new home, and those would not change unless and until this commission would, at a subsequent time and in a subsequent application, consider and approve such changes. Somewhat related, council mentioned impact fees. Impact fees are a Public Service Commission rate-making matter. The application before you today is not a rate request. That is something that would be applied for at a later time, and there would be a form to address impact fees at that time. So I would say, in addition to jurisdiction, even if the commission had jurisdiction, and I would submit to the commissioners that the commission does not have jurisdiction over this contract, that the issues that council raises are neither ripe nor germane to this Section 215 application. I could certainly go on to address the merits of the contract. I have a diametrically different view as to what Tessie is and is not obligated to do under its contract. And there are certainly amendments to the contract that council neglected to put into his Exhibit A in the petition. But again, I don't think this is the venue and the place for that. And so I will defer on that. I don't know if Mr. Nutter has anything to add in
Nothing
addition to me.
Mr. Walsh?
Thank you, Chairman Winslow. Start in reverse order, and these are more, they're questions here. Mr. Cooper mentioned that Town of Milton failed to attach certain amendments to the contract. We're here and a little bit behind the 8 ball because in our discussions with the joint applicants and even having exchanged some discovery requests, we never knew about this contract. So never mind the amendments, I'm curious why Artesian didn't mention this. I'm also curious if DENREC knows about this contract. As far as the commission jurisdiction, well, that's correct. The commission doesn't have jurisdiction over, or at least the jurisdiction to change this contract. And I think if you're going to allow one party to a contract be bought by way of this acquisition, you have created a bit of a novation as to the parties within a contract by way of a commission order, novation being a substitution of parties. But that has to be agreed to by all parties within that contract. So I don't think that commission has the jurisdiction to do that either. I'm not saying that this order necessarily will, but it's not clear that it won't. And there are, as Mr. Mandalis referenced, this is an executory contract well on its way. I don't know that Tessie can change hats by way of ownership as to all of its outstanding common stock in the middle of this contract based on the obligations and, importantly, as Mr. Mandalis mentioned, there's been reliance. There have been permits issued, and that's bigger picture, and it would seem imminent that we're going to have court actions over this. So I would hesitate to favor, at this point, now that we have the contract and some more facts, favor entry of an order that might further complicate court actions, whether they may be some inequity, it might be damages actions in a court of law, but I think we need to pause and take a good look at this and see what this does to the contracting parties. And frankly, I would like to know why it wasn't discussed in Artesian's application. And just one last point, I heard a lot from Artesian as to the benefits. It's in their application, it's in their their amended application, the benefits to the Town of Milton residents. That may be, I'm not questioning it, but I do question if I were making an application like that and I was clearly going to benefit the Town of Milton, I would bring the Town of Milton on board, and this would have been a slam dunk. instead I've got this party, this town that I'm going to benefit opposing me. So is it a benefit, or is there something else here? I'm not, I have trouble believing that it's both. That just doesn't seem to gel very well. So I would, maybe this needs to be vetted through a hearing examiner. I don't know. I'm not suggesting it. I'm just suggesting that entering this order based solely on what we have here today may be premature.
So staff has looked at all of the pertinent statutes and rules and regulations, and is there any violation of them with respect to the agreement between the parties to execute the plan they have?
Well, if we take as truthful what Mr. Mandalis presented today, which I think is fair to look at both sides and give them, assume that those are proper and truthful, then is the purpose still proper? And if it's really to the benefit of Milton and in the public interest of Milton, then why wasn't Milton a joint applicant? And if it's in accordance with law, then I don't believe that Section 215 has within its penumbra this idea that you can alter a contract which was never before the commission. I don't think that's part of the 215 checklist.
When was public notice given of this application? What date?
The initial, it was filed first, geez, the amended doesn't have. September 7th was the first one. But there's the amended was filed the 30th, and then we had some discovery issued. And hindsight being 2020, the DPA sent some excellent discovery. I thought we sent some excellent discovery. I would have asked for any contracts between either of the parties and the town of Milton had I known they might be out there. I would have assumed that the application, even supplemented, would have mentioned it. So I have some hesitation here as to staff's memo and proposed order. They were submitted without the benefit of the town of Milton's petition and this contract, and now I learn amendments to the contract.
Ms. Iori?
Thank you, Chairman Winslow and Commissioners. Originally, the DPA was not going to take any position on this application, but that has changed. And that changed on, actually it changed on Monday morning because I was on vacation on Friday when this came in. I read it on Monday morning, and as I said to my client, well, this changes things, doesn't it? And I think it does change things. At no time, during the discovery period, and we had a conference call with both Artesian and Tessie on the line. We asked them what the town of Milton's position was, because the answer to that question, for the DPA at least, would have had a significant bearing on whether the proposed transaction is consistent with the public interest as required by Section 215. The first time we asked, the applicants said they hadn't discussed it with the town. The second time we asked, they gave us the impression that the town was okay with the transaction. So we did not ask any discovery about Milton. Now, the amended application doesn't say anything about any contract with the town of Milton. It is utterly silent on that. If the application or the amended application had mentioned it, we certainly would have asked for a copy of the contract. And we perhaps would have moved this along, this might have arisen faster than it actually did. But it is clear now from the petition to intervene that Milton filed and that the commission has granted, that Milton does have a problem with this merger. It's not all hunky-dory. Now, with respect to the statement from Tessie that DENREC has imposed a timeline, we actually asked that question too, whether there was an issue that DENREC was requiring them to clean up, so to speak, and they said yes. So the public advocate contacted someone at DENREC. They said no, there was no timeline on it. But more importantly, there's nothing in either the application or the amended application to support that representation. If time really was of the essence, you'd think their amended application would have said something about that. Now, it is entirely possible that the applicant's proposal is consistent with the public interest. And according to the amended application, it would cost less than the agreement between the town and Tessie. But the agreement between the town and Tessie also contains provisions regarding the elimination of the outfall pipe and the demolition of the existing treatment plant, none of which are addressed in the proposed in the application. And so those are public interest considerations that, were it not for the town of Milton coming in with its petition to intervene, we would never have known about. Now, in its petition to intervene, the town of Milton said that if the commission was going to approve this transaction, it had some conditions. I understand now that the town of Milton is not asking for that they are asking that the commission postpone consideration of this for some time to allow them to have discussions with AWMI and Tessie. And if that is the case, then I don't need to go into what the DPA's positions would be on those conditions. However, the commission has an issue here, and that is that Section 215 gives you three options, as it were. One, you can approve it. Two, maybe four options. Two, I feel like Monty Python in the Spanish Inquisition. Two, you can approve it with conditions. Three, you can reject it. Or four, you can do nothing, and if you do nothing, the transaction will be approved by operation of law. The DPA would suggest to you that the options regarding approval with conditions, or allowing it to go into effect by operation of law would not satisfy the commission's obligation to find that the transaction was consistent with the public interest. The DPA would recommend that the commission reject the application, and this is without prejudice to AWMI and Tessie, refiling an application that addresses these, what I would suggest are very important issues that AWMI and TESI were completely silent about in their application. Thank you.
Thank you, Ms. Iori. Ms. Emerson? Short
Thank you, Chair.
rebuttal.
Yes, there's a few things. In no particular order, we did request in paragraph 3 of our amended application, it says the applicants respectfully seek expedited review and approval of the instant application as the parties have agreed to complete the transaction on an accelerated basis due to contractual arrangements surrounding the proposed construction of Tessie's wastewater treatment plant to serve the town of Milton. Beyond any disagreement that there may be over DENREC timing, there are additional permits, specifically one I know of from the Division of Public Health, which expires if construction hasn't started by December of this year. So there's other timing considerations as well.
Excuse me, Mr. Chair. May I please interrupt?
Yes, please.
I have a question for clarification, if you will.
Yes, sir.
You mentioned expedited consideration because of a milestone date in December that has to do with the construction of a plant by Tessie, yes?
I mentioned those two things, but not as consequential. So we did request expedited review, but that was based upon contractual arrangements surrounding the proposed construction of Tessie's wastewater treatment plant.
Yes, that's what I thought I heard you say. So
Yes.
contractual by whom to perform? By Artesian or by Tessie?
No, I understand those contractual obligations are between Tessie and the, I guess, bidder, the selected bidder regarding pricing. But Mr. Cooper or Mr. Nutter could, I think, speak more to that.
Okay. That, I yield back.
And as I said, there's other timing considerations, but that was the basis of the inclusion of that request in our amended application. There were several questions raised for Artesian, and I will try to address them, but please let me know if I don't address any of the questions that you raised. As to why Artesian did not mention this contract in its application or amended application, I want to be clear that this is a joint application between Middlesex and Artesian Wastewater Management, Inc. As an initial basis. This is the contract that he's referring to which we were not permitted the opportunity to reply in writing between the time it was filed and today, is a wastewater services agreement with which I'm sure you're all very familiar. The agreement is just one of many wastewater services agreements that Tessie has with its customers. We still do not see in that wastewater services agreement any contractual obligation for Tessie to construct the plant on Sam Lucas Road or to construct the water main down the length of Sam Lucas Road. We do not agree with the, I guess, allegation that we represented on 2 calls with the DPA. On one, that we had not talked to Milton, and on one, that we gave the impression that Milton was fine with this transaction. We, Artesian Wastewater, have requested to meet repeatedly with the town of Milton in order to get them, quote-unquote, on board with this application. Understanding that we are not Tessie, we're not parties to any contracts or any wastewater service agreements or any other type of obligation with Tessie to construct this plant or the water main. We did attempt to discuss with the town of Milton this application, the construction of our SURF plant, how that would impact its residents. We specifically and most recently have attempted to engage the town of Milton on October 18th and October 25th. In each of those, in response to each of those, Mr. Mandalis stated that essentially either did not offer for us to meet with the town or said, it's clear we cannot work this out before the Public Service Commission meeting this month. Consequently, we'll be filing a petition to intervene with the Public Service Commission. Again, that was on October 20th, on October 18th. However, the water main is important to the town, and I do not see any way the town can proceed without intervening at the PSC unless Tessie/Artesian honors its obligation to extend the water main. To be clear, Artesian Wastewater nor Artesian has any obligations with the town of Milton with respect to this plant or the water main. On October 5th, he said the town is always willing to meet, but that doesn't seem possible prior to the PSC hearing. We certainly could have accommodated that in our schedules. We also asked for any documents that support or substantiate the alleged contractual obligations to, or otherwise, whether they be quasi-contractual or detrimental reliance, that would support his claim that there was a contractual obligation. Not, again, not to be repetitive, but not because Artesian has any agreement to this, but to understand this transaction and to come into both this meeting and any meeting with the town of Milton with a full understanding. Mr. Mandalis, instead of providing any of the addendums or providing any other documents, simply referred us to the addendum, or I'm sorry, to the exhibits that he filed with his application. So we have likewise been aware of this issue for a short period of time. We're not afforded the opportunity to respond in writing. We could have attached exhibits. I have here the addendums. I have emails from Mr. Mandalis where we've offered to meet with the town of Milton. I'm going to address a couple other issues. It was noted or asked why we were silent in our amended 215 application as to the contract to construct the water plant or main. Again, not to be repetitive, but we don't think that there's any contractual obligation. And as an initial matter, because I was unable to share input at the beginning on the procedural issues, I agree with Mr. Cooper that this is wholly unrelated to this proceeding, this contractual dispute. Tessie will still be the same entity. It will have a different parent and would survive with the same rights and obligations that it has now, as Mr. Cooper said. We agree that the commission does not have the authority or the jurisdiction to grant the requested relief. And the relief that he requested, this commission does have authority and jurisdiction to grant, would be in a rate-making proceeding, which is not what we're here for. We also think that this is just an improper use of the commission as a bargaining tool in order for the town of Milton to obtain relief that it either is not or is questioning whether it has a contractual right to obtain from the town. Without having the opportunity to provide a written response here, seeing that this commission is not the proper forum, does not have the authority or jurisdiction, we suggest that this is completely irrelevant. It should not hold up a ruling on 215 application. It's not germane to Artesian Wastewater's acquisition of 100% of the shares of Tessie.
Mr. Cooper?
I'm not going to add much more to Ms. Emerson's very robust response, certainly on communications with Milton. Tessie has tried to be and has been very deferential since under the transaction, Artesian would be the new managing utility, that outreach come through Artesian, and Artesian certainly has gone forward with that, and Ms. Emerson has accurately recited the recent history with regards to that. A couple of just additional points. DPA mentioned that they spoke with DNREC and that DNREC did not mandate it. That is not what I had argued earlier. I said the timetable for completion was agreed to by DENREC, not mandated by DENREC. So I wanted to at least make that important distinction there. And then finally, I'm going to come back to where I started. This specific Section 215 application is for a stock purchase agreement. If this agreement is approved, Tessie, the entity that exists today, is the same Tessie, the entity that is existing tomorrow, the only difference being a different corporate parent. All of the rights of Tessie, all of the obligations of Tessie would survive this specific transaction. I do concur with Ms. Emerson's recitation that Tessie does not have a contractual obligation to construct the Sam Lucas facility. That is a substantive argument that I could certainly make in a court of law because it's not appropriate to be raised here, but Ms. Emerson did accurately recite that.
Chairman, may I add one
May
more
I-
thing, please?
Ms. Emerson?
Thank you. I did just want to point out as well that while we are focused on the customers or the interest of the town of Milton, there are other customers throughout the county and the state that would benefit by this transaction. And indeed, the residents of the town of Milton would benefit from the transaction. As I pointed out, just the gross difference in rates in the cost per gallon between the two plants and the elimination of the need to construct a $23.9 million plant. But as you can see on this map, there's great financial and operational efficiencies and synergies that would be realized by consummation of this transaction. And I think that everybody can see, just looking at that service area, that it's not just the town of Milton. And while those residents are important, very important, and I'm sure would like to keep their rates down and not pay for a $23.9 million plant, we should keep that in mind as well. And then one other thing that I'm not sure is before the commission yet. The pipeline that is proposed to be constructed, the water main down Sam Lucas Road, that would go from the plant that was proposed to be constructed up to Cannery Village Phase 4. There is and it would cost an exorbitant amount of money. There's a much shorter piece of pipe that could connect Cannery Village Phase 4 to the system that would be significantly less money. So not constructing this main, the length of main that would go to this plant on Sam Lucas Road, one, would not cut off Cannery Village Phase 4 from the service that it needs, and two, would be much less expensive for the ratepayers. Additionally, it's a water main, and this is a wastewater proceeding. Just wanted to point all of that out. Thank you.
Mr. Mandalis?
Thank you, although I think the public advocate, did you want to speak?
No.
Thank you. I appreciate that, Mr. Chair. A few things. Let me start just by first recognizing and commending and thanking Mr. Walsh and Ms. Iori for their comments on the application. It's not easy coming into something like this with a group that meets. I mean, the air in the room was kind of light before we got to this application. I'm sorry to be the one to kind of to bring it down, but I appreciate that everybody listened and responded honestly and truthfully and thoughtfully. With regard to communications that the town has had with Tessie, I think Mr. Walsh said, we should have been a joint applicant. We didn't have a seat at the table. I mean, as I mentioned earlier, the town of Milton had been asked by Tessie, by Tessie to object to artesian CPCN applications. All the while, this transaction was being drafted, consummated, discussed, and the town was unaware of it. Instead, we were asked to put ourselves out as objecting to Artesian's CPCN applications, who was in the background negotiating to become the parent company of Tessie. So as to communications, we were in the dark until it was publicly announced that this was going to happen. So, and that was only a short period of time between then and this application. With regard to the exhibits to the contract, that is completely an oversight by my law firm and me, and not the town of Milton. And to the extent those exhibits aren't attached, I don't have the full filing with me. To the extent they're not attached, I'll have them on the docket by close of business today. That was just completely an oversight and not intentional in any way. With regard to the contract and whether there is an obligation to build the plant on Sam Lucas Road, I agree again that those contractual obligations, the parties and the town can dispute them, and that is specifically not your jurisdiction. I will note that on page 4 of the contract, it mentions Tessie will purchase 18 acres of the 20-acre parcel located on Sam Lucas Road for a sum identified in section 14. It mentions on page 12 that the town will annex the Sam Lucas Road development. When complete, the town will take ownership of the 20 acres referenced above and agrees to sell to Tessie 18 acres in accordance with the above. If this does not occur, the town and Tessie will need to renegotiate the terms of this agreement as the proposed land for the plant is no longer available. So it's clear in my mind that the plant was supposed to be on Sam Lucas Road, and that's something I would love to have the discussion about that and how to resolve it. And that's very candidly what I'm asking for today, is just a short deferral so we can engage in those conversations. As to time being of the essence, what is occurring is that Tessie, recognizing its obligation to build a plant for the town of Milton, has went out on the market, sought bids from contractors to do the various pieces, including extending the water main, including building the plant, all the things that have to happen. They've went out for bids, they've got bids back. The bids will expire soon. And if the bids expire, those contractors have no obligation to honor the bid amounts. So Tessie's concern is that if these bids expire and this transaction, the 215 transaction, isn't consummated, then Tessie's in the unfortunate position of having to rebid those contracts and possibly the prices get hiked. I mean, my only response to that is the contract between Tessie and the town is 2007. Since 2007, the town has been saying, Tessie, when are you going to build our plant? When's this going to happen? We know we're supposed to get a new wastewater treatment plant. We'd like to get it off the Broadkill. When's that going to happen? So we're now, 14 years later, and a month deferral is going to matter?
Mr. Randall, let me just interrupt for a second. What sort of amazes me about this whole situation is that I'm looking out in the audience there, and I see David and I see Bruce, and I can just sort of envision them swapping chairs. I mean, and you've got one organization which is as financially secure, if not more, than the one that they're buying the stock from. And by the way, I don't think I've ever seen a town or a party come in to intervene in a stock purchase agreement like this in the 17 years I've been on the commission, except for perhaps one rather large item that happened a couple of years ago. I'm having a hard time, and you've acknowledged the fact that there might be some damages that flow from this rescheduling, et cetera. So the city of Milton obviously has thought about those possible damages that your citizens may have to pay for, and you really feel it's in your best interest to run the risk of this whole, what looks like a beneficial agreement to fall apart?
I think that we're all trying to get to a point of acknowledging that the transaction is in the public interest. And I appreciate that this is your role and that you've seen these two organizations. So I don't, for a moment, discount your representation that they're almost can swap chairs.
Mr. Chair, may I ask two questions, please?
I've heard Mr. Cooper say a couple of times that the transaction will take place, and once it happens, the contractual obligations will remain in effect. I've heard him say it twice, and I've documented it. So my question to you on behalf of the town of Milton, if all of the contractual obligations will be fulfilled, What am I missing that you know that I don't, that gives the impression or the conclusion that these obligations will not be fulfilled?
Thank you, Mr. Gray. It's a wonderful question, and it's a pretty easy one to answer. Over the course of the past couple years, TESI has very much acknowledged its, what the town believes to be its contractual obligation to build a plant at the Sam Lucas facility. It sought approvals from the state, it sought approvals from the town, it took possession of the land. Then, within the last 6 weeks, TESI has said, no, changing our mind. We're gonna do a deal with Artesian. That plant's not gonna get built. We're not gonna extend that water line. So I'm suspect that after the transaction, the contractual obligations maybe will not be honored. That's just one example, but it's a big one, building a plant or not building a plant.
Okay, so one last follow-up question. Is there among the evidence in the record a document that confirms that these obligations will be adopted by the buyer?
There is nothing that I've seen on the record, other than the statements I've heard today, indicating that the obligations will be adopted. Now, certainly, in a stock purchase agreement, the entity isn't dissolved, so the entity is there, and contracts that are in place remain in place. That's why I do feel as though the town will have strong legal claims should this need to proceed to a court proceeding. I'm just very hopeful that it need not do it, because in my, sort of you get a feeling for these things, and I feel as though this can and should be worked out among the parties. We, the town, just wish we were at the table a little bit earlier to make sure that happened.
I've got that part. So I'm just struggling in my mind to figure out if the obligations will move forward and be adopted by the buyer, and you felt that the obligations were important enough for the public interest, then therefore, why is the public interest not served?
Well, certainly, I'm sorry, if you'd like to, I defer.
I think he addressed a question to you, Mr. Mandelis.
Well, on behalf of the town of Milton, I think that the town has expectations, and the extension, the ways in which the town has extended itself, for example, to the developer of Cannery Village 4, if the obligations of TESI are not honored, and for example, the water main is not constructed, then the developer now has a claim against the town, because the town has made a representation to the developer that you can develop and you can sell homes, and yeah, you're approved, and this water main is coming through. And now the developer is gonna say, Milton, you said yes, and you said there's gonna be a water main there, and you didn't deliver. So now the citizens of Milton are gonna be on the hook for some court claim that's gonna be whatever amount of litigation dollars.
So it comes down to, if the obligations are adopted by the buyer, then the public interest is served. I'm still struggling to figure out, are these obligations being adopted by the buyer?
Chairman Winslow, may I try to respond?
I'm going to make sure that you get it every time you want to speak. Ms. Iori, I would never let you out, believe me. But I want to hear from other people first, so you'll have the benefit of their input, and you can speak even longer.
I don't need the benefit of their input. I can
Well, I
make
know
this
you
really
don't.
quick.
But sometimes you're wiser if you do listen, and perhaps sometimes you will learn something. Mr. Mandelis, you're still on the, are you
Thank you,
finished
Mr.
your
Chair.
comments?
Thank you, Mr. Chair. I just, let me check my notes to be sure. I appreciate that Ms. Emerson indicated that, another way to run the pipe. I haven't looked at all the different options. Again, it's another thing that perhaps could be discussed if we had some time to sit down and have those conversations. So I thank you for the opportunity to comment.
Guess who's next?
Would that be me?
It'll be you, please.
I think that the question is actually pretty easily answered. The amended application says that the combined company is going to use the SRRF that Artesian either is building or has already built for its obligations with respect to the town of Milton. And what you haven't heard from either Artesian or Tessie is that they are going to comply with the terms of the contract. If you read the application, it talks a lot about the SRRF and using that. And that is what they are basing their claim that it is better for ratepayers on. Thank you.
May we hear from Mr. Cooper? Mr.
Tessie,
Cooper?
let me repeat this again. Tessie today will be obligated to the contract. Tessie tomorrow, if the commission were to approve this Section 2015 application, those obligations pass forward, that contract would be honored. End of sentence. Let me ask this too. Let's say that Sam Lucas Road is rebid. Rates would very likely, at some point in the future, as a result of that, go up, very possibly higher than a rate level that they would benefit from through the operation of the SRRF plant. How is that in the public interest?
Mr. Walsh, you have a few more words to finish this thing off?
I question if Mr. Cooper is going to, and I'm not questioning his representation, but what I didn't hear was the solution of getting together with the town of Milton and having a proposed order which incorporates and attaches the contract we've discussed and any amendments. That's a possibility. I see Mr. Mandelis nodding his head. If the applicants had come here and were absolutely certain that this contract did not do anything to this 215 application, they would have put it out there and shot it down right out of the get-go. Instead, we didn't hear about it at all. So maybe a solution is to have a new proposed order to make sure that this contract is not somehow pushed aside, the rights aren't affected, there are third-party incidental beneficiaries, and that would be a proper way to make sure that the parties and the public interest is served and that it's done in accordance with law.
So you want to change the order so that the order says that the contract, which is already legally binding upon the present entity, will be binding upon the entity as it was before the stock purchase agreement, after the stock purchase agreement.
But that's not clear in the order, and it's not clear in the stock purchase agreement.
Yes, Ms.
But
Tur-
is it not the case in any stock purchase agreement of a corporation where you're purchasing a subsidiary that you, in that purchase, assume the obligations of that company? So you avoid a situation where, you know, my parent corporation is whomever, and I decide I'm going to go to another, have another company buy me out, so I'd no longer have any liabilities or any, obligations and contracts. But those contracts transfer with the purchase. Am I wrong?
Commissioner, you are not wrong, and I am very familiar with contracts and the assumption of them. Here is the issue. What is supposed to happen under the stock purchase agreement? We do not have, in this cog of the gears here, and this cog of the gears being the underlying 2007 contract, what the parties have told us today is that they're going to grind. So if you issue an order saying you purchase it, you're forcing them to grind that transmission by way of court action, because assuming liabilities is fine if you know what you're assuming, but you have in the request, certain things that are going to be done and taken over, but they don't quite mesh with the underlying gear over here, and they must do so, or you've done something to a contract which I don't think the commission has the jurisdiction to do.
Thank you.
Mr. Walsh, I don't know if I understand that. I mean, we don't have any jurisdiction over the contract. We have a statute with respect to 215, and everyone agrees the conditions of that statute have been met. Obviously, we're concerned about the public interest, and as you'll recall, I made a motion and based upon the public interest involving the town of Milton and a water company not to be named, and we did not approve a CPCN because there was inequitable grades or classifications in their water rate system. So yeah, we can, I think we do have the power when there's something in the public interest. But it's hard for me to conceive why we should use something over which we have no jurisdiction and really no expertise and use that as a public interest argument and then say, we're going to put off this decision or we're not going to approve it. We don't have jurisdiction, and yet we're going to not approve it because of the public interest relating to those things that we have no jurisdiction over. We've got two just highly competent professional organizations here. They've made a business decision. There's a statute that says what we got to look at, but it's been looked at. And I think that the real danger here is not that something's going to go wrong in the public interest. The real danger here is that we'll shoot ourselves in the foot, and Milton will end up with more problems and more litigation expenses than they ever dreamed of. And I think that the city of Milton is smart enough that if there's a better way to do the mousetrap, that they're going to see the advantage of it and see the money savings and see the benefit to their citizens. And if it changes the contract, wow, it's working the way it should work, right? It's a 2007 contract. Things have changed. Technology has increased. But we shouldn't be putting ourselves in the middle of that argument. Who knows when that's going to be resolved by Tessie and Artesian and the town of Milton? 2022 sometime? I don't know. I think we've had enough argument. And any more comments by the commissioners? Anybody want to make a motion?
Excuse me. May I just say one thing?
Mr. O'Brien.
Mr. O'Brien?
The only thing I want to point out is that proposed order 9909, which grants the 215 application, apparently that was drafted before the town of Milton's request came in for intervention and clearly before they were granted intervention. So if you are voting in favor of the application, I would only suggest that I be given the opportunity to work into the approval order, the granting of the request, and the objection from Milton and your reasoning for denying the objection and granting the application. So in other words, if you're going to vote in favor of it, but allow your counsel to restruct the proposed order to include Milton's objection. Thank you.
May we have a motion, please? I thought Commissioner Gray was going to make it.
Mr. Chair, I think on this matter, I don't want to really be in the middle of trying to resolve a contract dispute, but I see some merit to the arguments from staff and from the People's Council. So I'm going to actually abstain on this matter, so I have no order or to propose. I have no motion to make.
Commissioner Drexler?
I would like to make a motion to approve proposed order number 9909 as amended with the language that Mr. O'Brien has proposed.
I will second that motion.
Is there any discussion amongst the commissioners? All those in favor signify by saying aye. Aye.
Aye.
Aye.
All those opposed?
I abstain, Mr. Chair.
And all those abstaining, that's Commissioner Gray. Commissioner Curry, are you still out there? Are you on mute? Commissioner Correa? Okay, there was 3 in favor and 1 abstention. Matter passes or carries. Thank you very much, everyone.
Thank you, Chair and Commission.
Thank you. You as well.
The hearing schedule is next, and I note that there's nothing on the hearing schedule. Is there anyone here from the public that wishes to make public comment to the Public Service Commission? Mr. Hartigan, our Executive Director, is next.
Thank you, Mr. Chairman and Commissioners. Just 2 items. Our next meeting will be November 17th. At that meeting, we will have 2 hearings. The first is on our proposed regulations for community energy solar facilities, our second favorite regulation, Regulation 49. The second hearing will be on Delmarva Power's application regarding SOS rates, the PCA and RARM filing. Thanks.
Is that all?
That's all.
Okay, thanks, everyone, for attending, and we'll see you in the next meeting. We're adjourned.
Chairman Winslow, Commissioners, I am sure you will be delighted to hear this, but I will actually not be at the next meeting because I'm going to be over at the Supreme Court having some fun with Chesapeake.
Oh, good.